Tribunal, NCLAT ruling, that the 90-day time limit under Regulation 2B for filing of revival scheme under Section 230 of Companies Act 2013, it is not mandatory. It is directory in nature. We'll see the background of the case. The ruling comes from Chennai bench of the National Company Law Appellate Tribunal. The case involved a company named Sarda Agro Oils Limited, which was undergoing liquidation. So during the liquidation, a scheme of arrangement under Section 230 of Companies Act 2013 was proposed by Mr. Prakash Oil Depot. This scheme was aimed at reviving corporate data instead of letting it to the liquidation. Now here only the issue is the scheme was filed beyond the 90-day limit as the prescribed Regulation 2B of the IBBI Liquidation Process Regulations 2016. So earlier NCLT Hyderabad had rejected the extension on the ground that the time limit was breached. So but the promoters appealed this rejection to the NCLAT. So we'll see what Regulation 2B says. Regulation 2B of IBBI Liquidation Process Regulations 2016 provides that a scheme of compromise or arrangement under Section 230 of Companies Act 2013 must be completed within 90 days from the liquidation commencement date. So scheme has to be completed within 90 days from the liquidation commencement date. So this provision was added to streamline timeline and avoid indefinite delays. But the key question is 90-day time limit is absolute and mandatory? This is a question. Or does the adjudicating authority, that is the NCLT, have the discretion to allow an extension if the scheme is viable and backed by creditors? So what was the NCLT observation? NCLT observed that the 90-day period under Regulation 2B is directory and it is not mandatory. And Section 230 of Companies Act does not prescribe any rigid timeline, rigid time frame for proposing or implementing the scheme. And the IBC core objective is revival and resolution, not liquidation. When stakeholders, including security or support viable scheme, they give consent, then adjudicating authority should not take a hyper-technical view. This is what NCLAT observed. NCLAT further highlighted that the procedural delays, especially caused by institutional audits like internal bank approvals, cannot be treated as intentional defaults. So in this case, the EMD of rupees 4.3 crore earnest money deposits had already been submitted, showing commercial intent and credibility. So the reliance on landmark cases, the appellants in this case relied on number of landmark judgments to support their claim. Those include Swiss Ribbon versus Union of India, where the Supreme Court reaffirmed that resolution is the primary aim of the IBC. And they also relied on Y. Sivaram Prasad versus Dhanapal, where it was held that the liquidator can explore revival even during liquidation under Section 230. And another case, Arun Kumar J versus Jindal Steel and Power Limited, which clarified that the promoters barred under Section 29A cannot propose a scheme, but otherwise revival schemes are legitimate tools under liquidation. So the NCLAT also referred to its own prior rulings Bharat Sharma versus Reshma Mittal, and another case, Sanjeev Mitla versus Madhusudan Rao. These cases reinforce that revival must be preferred over liquidation if it is a feasible and commercially sound. This is what NCLAT observed, and the role of stakeholders and SCC. SCC is Stakeholders Consultation Committee. The tribunal also stressed the role of SCC. If the SCC, which includes financial creditors and other stakeholders, agree the scheme, their commercial wisdom must be respected. So it clarified that at this stage, the judicial authority should only review procedural correctness, not the merits of this scheme. So this aligns with the principles laid down in multiple IBC cases. The court should not interfere with the commercial wisdom of creditors unless there is evident legality. So the final ruling and directions. In its concluding observations, NCLAT quashed the NCLT rejection order and allowed additional 90 days from the date of NCLAT judgments to complete the scheme. Directed that scheme be processed in accordance with the section 230 subsection 5 of the Companies Act 2030 and rule 8 of the compromise and arrangement rules. So this is a huge relief to the company. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of the latest videos. Thank you.